Hi, good morning all, and welcome to today's webinar. I know that everybody will have busy diaries, and I'm therefore grateful for you joining us today. It's great to see some familiar names, but for those I haven't met previously, my name is Wendy Moore. I'm the Healthcare Claims Executive for Lockton Insurance Brokers, and I'm joined today by my colleague, Account Director Alex, and Regulatory Partner for Mills & Reeve law firm Duncan Astill. With the Care Quality Commission fully launching their new assessment framework for care providers later this year, which has been delayed and was due to start at the beginning of this year, now is the time to make sure that your organisation is fully prepared. We understand the challenges that care providers are currently facing and the potential impact in moving towards the new framework. Using this time effectively, we want to help you to get ready for the CQC's change of approach. Consider the inspection challenges that you are currently facing, and also discuss CQC's investigations, as we have seen an increase in this area with some high-profile prosecutions hitting the media recently. As you can see from the screen, we'll have a full agenda to cover over the next hour, and we will close with any questions you may have. So without further ado, may I please hand over to Duncan.
Thank you, Wendy, and hello and good morning to everybody. As Wendy said, I'm Duncan Astill. I'm a partner in Mills & Reeve in the regulatory team. And if you're as old as I am, you might feel a little bit like an ABBA song of "Here we go again" with the CQC changing, bringing in a new approach to their regulation. But I think, as we'll see as we go through and look at the new approach that they're going to take, it does feel a lot like evolution rather than revolution. We still have the same 4 ratings and we still have the same 5 domains. But if we just move on to the next slide, you'll see that we've had a regular and substantial number of changes to how health and social care is regulated since 2000, but the pandemic has really led the CQC to looking at an alternative way of delivering their regulation, a way of assessing providers. And in 2021, they launched their new strategy for the future that we're going to look at in a bit more detail. So I don't know whether you can see the on slide 3. We seem to have dropped out of presentation mode. But what we're going to do first is look at a new approach to the assessment before moving on to look at the CQC's prosecutory powers. So next slide. So the CQC announced their strategy really last July 2022, and they trumpeted it as a new dynamic approach to regulation, where there were going to be no set timeframes really for their ongoing assessments. They're moving away from the sort of inspection-led or inspection-heavy approach to make more frequent assessments of quality and to enable them to respond to concerns by carrying out inspections and regulatory activity on the basis of risk. Will be much more data-led rather than time-led to allow them to be a bit more flexible. We're yet to see whether that will come to fruition, but I think there are definitely some positives as we'll come to about this new approach. So we move to the next slide. So you'll see from the strike out there that the new framework was going to launch in January 2023, we've not been given a definite date, but they're saying late 2023 before this comes in. They're currently testing their technology, getting ready for launch, which they're going to be doing from spring, and then they're going to be launching a new provider portal and guidance in the summer. So that's where we'll get to see a little bit further under the bonnet. But what is clear is that your interaction with the CQC is going to move to a new provider portal that you'll be using to upload evidence on a fairly regular basis for them to continue to provide the public with assurance about the quality of care that you provide. So it's going to be a single approach for all health and care providers, but they're also going to be looking at the integrated provider systems that are now operating, and they've got new powers to look at a health system rather than just individual providers. But you'll see that there is going to be a real emphasis on culture, on a safety culture, and organisations demonstrating that they're learning and improving. So on the next slide, I've summarised the sort of key elements to the framework. So you'll see there's going to be multi-point assessments, i.e. that it's not going to be a set piece following inspection where you'll have a huge report. Everything will be assessed and rated at that point, and you get an overall rating published on the website. Because they're expanding the sources of information, they're looking at this in real time, they will be able to change ratings more often, and that I'm sure will be an improvement for many of you, as it's one of the constant sort of complaints we get from people is they've had an inspection, there's been an issue, they've resolved that issue, but then they have to wait 1, 2, sometimes even longer before they get to they're able to have the service re-inspected and get a new rating. So that should certainly help. They are looking specifically expanding the source of information, going to be asking care workers a bit more and getting more feedback from people using services. They will then use that information to create their own sort of dashboard, they're calling it, but basically a way of them identifying when they need to intervene, when they need to get involved. They're going to move away from the really long narrative inspection reports. So rather than having I've just been looking at one with a client that was 176 pages long. So I'm not sure many service users will have read all that. So they are going to be providing a different way of communicating their assessments to the public, which is likely to be short statements and sort of benchmarking data. The 5 key questions remain. So they'll still be looking at providers as to whether they're safe, effective, caring, responsive and well led. But with new statements, effectively, they're actually we statements. So it's a statement that the provider can effectively provide evidence to show that they are meeting, and those 34 quality statements will replace the key lines of inquiry. And I think the biggest change will be that a lot of the inspections will probably be much shorter, that it will still be important for them to go in and observe excuse me, the actual delivery of care, but they will be assessing a lot of information before inspection that are uploaded through the portal, and they say they're going to be looking at a little more detail at the outcomes that people receive. Move on to the next slide. The CQC have set out 6 categories of evidence that they're going to look at in order to come to their assessments. So you'll see there specific evidence taken from people who use the services, feedback from staff, feedback from partner organisations, their own observation during inspection, looking at the processes and procedures that you operate and the outcomes that you achieve for the people who use your services. So they're going to sort of chunk all the evidence up into those different areas and use that more holistically to reach conclusions as to judgment. So in the next slide, you'll see that the big change is that they're changing completely the scoring framework that they're using and to come up with this, come up with their rating. So each of these quality statements basically gets scored, and you get a score from 1 to 4 for each of those quality statements. All of those then individual statements, you get a score for the domain, and then the whole thing's sort of aggregated up to give you an overall score, which then feeds into the result. So it seems to me a little bit like a procurement scoring exercise, where individual scores are given out for individual questions, and this is all aggregated to give you an overall outcome. So if we move on to the next slide, you'll see there the 6 different stages of this. They review the evidence, apply the score to each of the quality statements, and then combine that to give a total score for the relevant key question. That generates a rating for each question, which is then aggregated to give the overall rating. And if we look at the next slide, you'll see that the ratings themselves then are given bands. So to get a good rating, you need to achieve an overall score of between 63 and 87, and obviously over 87% as outstanding. So the idea behind all this is to bring in some more sort of objectivity and consistency in ratings, that there's going to be to some degree less reliance on the individual judgment of inspectors, that it will be more data-led and a bit more scientific in how they get to a rating. Obviously, there's still an element of judgment in there in whether you score a particular area 1, 2, 3, or 4. The individual underlying scores for the quality statements will still be fairly dependent on the judgment of the inspector, but it should lead to a little more transparency, certainly in how those statements, how those scores are put together, and how those conclusions are reached. So if we move on to the next slide. So, is this a good thing? Well, as I said, I think there's definitely going to be more transparency how the CQC arrived at the ratings and what needs to be done to improve. You'll see, where you've scored well, where you've not scored well, and hopefully be able to target any further improvement. The benchmarking should be available. You'll be able to see how you're comparing on scores to other people, and you've certainly got an opportunity to get re-rated when you've made changes in between inspections and things. One of the interesting things is the CQC say at the start they're not going to publish the underlying scores, so you won't actually get to see the individual scores for individual areas, or they won't be publishing that. I expect that as a provider you'll get to see them, but in due course their plan is to publish all of the scoring. And that's presumably they want to sort of check it's working a bit more before they go and publish that information. But it should give a bit more transparency as to where the issues are for those looking at services. But any reasons not to be optimistic? Well, there's still a potential for the disconnect between the data and the reality, and certainly, judgments on whether a policy is up to snuff and things will still be in the hands of an individual inspector who'll be making a subjective assessment. And there's still the biggest sort of issue I really have with the CQC and the way they approach this is that there's still this huge disconnect between the regulations, what the law says you need to do in the provision of care and the quality statements. And it was the same under the current regime, where the key lines of inquiry and the domains themselves don't really, it's quite difficult to cross-reference them really to the regulations, and the actual words of the regulations, the law, does get sort of turned into something else really, which I think is a problem, particularly when they're looking at taking further action that we'll come to in a moment. So that's a very brief view on the new framework, but thank you. Yes, next slide. There are some other things just to be aware of, just to put on your radar, that hopefully you're all aware that as of last July, there's now an obligation on providers to ensure that staff are all trained and able to interact appropriately with people with learning disability and autism. So that came in last July. We've been signposted by the government for quite some time now about reforms to the Mental Health Act. So 2021, we had a white paper that was aimed at addressing a sort of high number of detentions, a disproportionate number of people from Black, Asian and minority ethnic who were detained under the Act, and some outdated process and procedures. We got a draft bill in 2022 that's been reviewed by a joint committee who published a report a few weeks ago, and we can expect that legislation to come through in the next year or so. So significant changes there. And then, of course, the long-awaited liberty protection safeguards that were first due in October 2020. I think April 22 was the next date. And I think there's been some noise suggesting it's going to be October this year, but I think the government are saying at the moment there's no definitive time, table in place. So we're still yet to see when that will come through. Okay, moving on next to investigations. So obviously, it is a sort of separate part to the ongoing monitoring, the assessment of quality, inspections, and the sort of day-to-day job of the CQC. It's also getting to be a much more significant part of the CQC role is to carry out investigations and bring prosecutions where there has been harm has suffered. So they've always had the power to prosecute providers for breach of the regulations, and the number of prosecutions is rising. I think we've seen a sort of big uptick really since 2016, but the issue was first really highlighted by Sir Robert Francis in the mid-staffs inquiry, where he felt there was this gap where the HSE didn't want to get involved because it was sort of clinical in nature, and they didn't have that level of expertise, whilst at the same time the CQC didn't, really was using prosecution powers against unregistered providers, but wasn't not completely the case, but wasn't bringing many prosecutions at all, or particularly investigating care issues. But it took a bit of time for that to change, but we've definitely seen an uptick since 2016. Next slide. So the offence, obviously there is the corporate offence, but just to flag that individuals can also commit the offence, very similar to health and safety legislation, that any director, manager, secretary of the organisation, or someone working in that capacity, if the offence committed by the organisation is committed by or with the consent or connivance of, or be attributable to the neglect on the part of that person, then they too can be prosecuted by the CQC. So it's pretty rare, even in a health and safety context, for that to happen. But just to flag, it is indeed possible. So next slide. So what to expect? How does the CQC go about using its criminal law powers? Well, generally what we see is that the CQC get information of a particular case. So all your reports to the CQC under Regulation 16, 17, etc. But equally, anything that they find from inspection or that's referred to them by the safeguarding team, etc., they may warrant an investigation. So there's no sort of hard and fast rule here, but what we generally see is that there'll be an initial approach from the CQC who will, say that they've opened investigation and make a request for information documentation. Sometimes they'll ask to speak to staff or come in and actually do interviews with individual members of staff, etc., gather more information, and then consider all that information to make a decision whether the particular case is at a scale to warrant any sort of criminal sanction. So next slide. And what we see is if they think that it's going to meet the threshold for a prosecution, the CQC will write to you. They seem to have sort of defaulted to this in the past. Regulators were much more wanting to interview people in person, but the CQC seem to be have now adopted this approach of writing to the provider with details of the case that it thinks it has against the provider, why it thinks you've committed a particular offence. Provide a limited amount of evidence. There's quite a limited disclosure duty on the CQC at this point. Warn you with a formal caution that you have even the corporate entity has a right of silence and doesn't therefore have to make any response at all, but usually provides a set of questions that it wants to be answered. And I think, as I've said at the bottom there, this is the key. This is the key opportunity that you have to influence the CQC and decide, help them decide whether or not this is a case that they should bring a prosecution or not. In settings like this, the regulatory cases with the health and safety executive have something like a 94% conviction rate, and it's probably even higher for the CQC of the cases that they bring. So it's really difficult to defend these cases in court. So this is really the key opportunity that you have to put forward your case, explain what happened, and try and persuade them not to prosecute. Okay, next slide. The important thing to say is that the CQC do have a time limit. They can't, other regulators like the HSE don't, but they have 12 months from the date that they have sufficient evidence and a maximum of 3 years from the date of commission of the offence to prosecute. And they do have to be sort of reasonably prompt. And in order to decide, they follow the Crown Prosecutor's test in terms of making a decision to prosecute. So they're not only looking at whether there are realistic prospects of success, whether there is a good chance of them securing a conviction, but they also have to assess the public interest test in deciding whether or not that this case is one that needs to be prosecuted. And again, that's where you can have some influence on the CQC as they go through that assessment and decide whether or not a particular case is in the public interest or not to bring. As I say there, we have seen the CQC under a bit of time pressure and skip some of the process, but important to know that 12-month time limit. Next slide. So during the investigation, sometimes we come across an issue regarding the disclosure of information that has been obtained for other purposes, or information documents that constitute legal advice. So it's just important to be aware of this, that if you're carrying out an investigation, a normal incident, and you carry out a serious incident investigation done by you as the provider for the purposes of learning any lessons to making any changes that need to be made, then that would be disclosable to the CQC or any other regulator. If, however, you've asked for legal advice, or you're clear that there's going to be a claim coming, and you start an investigation as part and parcel of putting together your legal defence to any reasonably contemplated litigation, or you're simply asking for legal advice on your potential liability, then it's possible that that information, which includes any steps they've taken to interview members of staff, interview people about what happened, and their sort of notes, as it were, of those meetings would be privileged, and therefore you can avoid disclosing them to the CQC or any other regulator. So it is just worth bearing in mind at the start of any significant incident to think about how you're going to investigate it, how you're going to move forward with it, and whether it's a good point for you to get lawyers involved. The next slide. So the CQC prosecution will result in a fine, and that fine is very dependent upon the circumstances of the offence. But the fine is unlimited. Next slide. There aren't any specific guidelines as to how CQC offences are calculated, but there are some very specific guidance for health and safety offences, and courts will generally use those because it's very analogous to follow through the same various steps to calculate the fine. So I'll just work through those on the next slides very quickly. So the starting point is determine the offence category. So they look at the culpability. Was this serious? Was it deliberate? Was it a long way from what was expected? So that's to assess the culpability. Then they look at what's the harm that is likely to have been risked. What would the foreseeable consequences of that be? To work out, and is that likely? It's very likely to happen, or not likely to happen. But they're effectively looking at both the culpability, the level of risk, and the likelihood of that harm arising, and then to consider whether there were a number of people exposed to harm, and whether the offence was a significant cause of the actual harm. So it's really looking at the sort of seriousness of the offence to determine, and there are some specific categories to determine the outcome. The next step, next slide, is really, once you've got all those, there are effectively some tables, and you've used those to identify the starting point for the organisation based on the size of the organisation in turnover. And it's important to know that is a turnover-based starting point rather than a profit-based starting point. Maybe that's something you can bring in later, but it simply says the bigger the organisation, the bigger the fine's going to be, really. The starting point can be adjusted then because of aggravating features, or such as cost cutting, but also reduced because of any mitigating factors, particularly action taken voluntarily to resolve the problems. Next slide. The court will then look at the means and the economic impact of any fine. They're wanting to both send a message, but the organisation the fine isn't designed to bankrupt or make insolvent the organisation. So it does at this point have a bit of discretion to take an appropriate approach, and we've certainly been successful in arguing to courts that the impact of a very large fine would lead to people losing their jobs, and that would be a bad thing, and therefore the fine should be adjusted downwards accordingly. Next slide. And then the other factor, and particularly in a healthcare setting that might be relevant, is just anything else that needs to be taken into account. But the impact on service users, particularly for public sector organisations, but I think it applies across the board really, that taking money out of an organisation by way of fine usually has an impact on the ability of the service to improve and the investment it can make. But the biggest single thing you can do to reduce your fine is to plead guilty at the earliest opportunity. That will lead to an automatic 1/3 reduction in the fine. And that's one of the reasons why the conviction rate is so high, because to plead not guilty does give you you are putting at risk that 1/3 discount, which, especially if you're a large organisation, can be quite a significant sum. So we do often see that influencing the decision. And that does mean we've had some very high fines. So the most recent one, Nottingham University Hospitals got an £800,000 fine. Dudley and the Dud group of hospitals, following the death of 2 people from sepsis, was a £2.5 million fine. And back in 2012, a care home was fined £500,000 for the death of someone with dementia from a fall. So they are significant sums that are being used, being given out by the courts. So that's all I was going to say there. So I think I'm handing over at this point to Alex, who's going to talk a little bit about insurance policy coverage.
Okay, so
thanks, Duncan. It's going to be Wendy on this bit.
Okay,
yeah.
Sorry.
No worries. So I'm sure you now all want to know what support is available when a CQC investigation is underway. So when CQC starts an investigation, please notify Lockton or your insurance brokers as soon as possible, so we can involve your insurers at an early stage. And this may assist with disclosure and privilege, as highlighted earlier. So the CQC will be seeking reassurances that there are no wider safety or quality issues following a serious incident. As Duncan has mentioned, this is the key stage and the main opportunity to prevent enforcement action and evidence your defence. It is important to be prepared, and this is where we can provide support and advice, ensuring that you and your colleagues are organised and ready for the investigation process and submission of evidence. So once CQC have confirmed that they are considering a prosecution, your insurers will usually appoint a panel law firm to support you through that process. A specialist staff will be interviewed and possibly under caution, and the findings and outcomes of any prosecution are likely to have a direct impact on inquests and or increase the likelihood of a civil claim being presented by the injured party, their family or representative. Just a reminder, it is also a condition of your insurance policy to notify insurers of such matters. So as you can imagine, insurance coverage varies dependent on the type of policy that we purchase. However, your insurance policy that covers public liability and medical malpractice should provide an indemnity for legal defence costs in connection with prosecution. This will also include an appeal against a conviction. It will cover for any offence or act that is committed or alleged to have been committed during the policy period, under various acts such as the Health and Safety at Work Act, the Health and Social Care Act, and corporate manslaughter. It is worth mentioning at this stage that under the PL and med-mal policies, fines or penalties of any kind are not covered. There will also be a policy limit for the total spend on legal defence costs in connection with regulatory investigations during the policy period. So we need to take a proactive approach and engage with insurers early on, which is key, because depending on the circumstances that prompted the CQC's involvement, insurers may consider support at an earlier stage than notice of prosecution. This will be with the intention of hopefully avoiding getting to prosecution stage and therefore containing and controlling the costs. So Lockton or your insurance brokers will make submissions to your insurers setting out the reasons why early support is required in order to convince the insurers to assist us early, as soon as possible, and allow for those legal defence costs to be covered under your policy or to erode your deductible. So we're happy to offer any advice and assistance on individual policies or matters, so please don't hesitate to contact us. As Duncan has highlighted, a prosecution can be pursued against the entity or your organisation, as well as individuals such as directors, senior management and registered managers. I will now hand over to Alex to provide some more insight into insurance coverage.
Thanks, Wendy. So one of the other lines of business which we wanted to talk about, as Wendy just mentioned, is the one which is in the middle of this slide here, which is directors and officers. So it's very important, based on the points that Duncan and Wendy mentioned around the ability for individuals to be named directors, managers, and anyone seen to operate in a supervisory role. I guess the first port of call here and the first advice that we'd probably like to share is to add to Wendy's point around early notification and making sure that we're working with D&O insurers if there is an investigation which is brought following inspection. And that's from a CQC investigation and also from other types of investigations like HSE investigations as well. And we make sure we advise all of our clients on that basis. Now, the D&O policy differs somewhat from the public liability and medical malpractice in the sense that the coverage operates slightly differently, certainly with respects to fines and penalties. So, for example, for civil fines and civil penalties, there is cover for individual directors under most D&O policies, although you need to make sure that you check with your broking teams the extent of cover which is available and any conditions around those clauses, because often there'll be conditions around them which talk about elements of negligence, which can negate the element of cover that you have. But it's one of the main differences in that some of those civil fines and penalties can be covered. Along with this, under D&O policies, you'll have criminal investigation and defence costs, similarly to public liability and medical malpractice, which are also important for early notification. The other really important point, I think, which you want to make sure you're working with your broking teams around is what we call failure to supervise coverage under directors and officers liability policies. Now, typically, this will appear as an exclusion around professional indemnity exclusions, which are excluded under D&O covers because there are separately available coverages for those, for example, like medical malpractice. But what's important is that directors can often be found liable for a failure to supervise certain clinical acts and operations within care homes. And we often advise all of our clients to write back failure to supervise coverage, which is really critical, especially with the change in CQC framework coming up. So those really are some of the most important points which I wanted to highlight around D&O. The other policies here are really sort of ancillary policies which are bought by some clients but not others, but may be relevant with changing legislation going forward. And typically, I think these relate to reputational risk elements and also potentially loss of registration and appeals. So that's a cover that I just want to speak on very quickly. Loss of registration or loss of license cover is often included under a property damage and business interruption policy. And often the coverage relates to effectively loss of income through loss of license, loss of home and loss of service users. Now, the challenge with some of these coverages is that often they require a physical damage trigger. So they can be unrelated to negligent care provided and therefore a CQC investigation being triggered. Now, that's not always the case, but for the most part, the market is not providing necessarily the right levels of cover that we're looking to see, and that's something that we're looking to change. But it's worth just reviewing with your teams the loss of registration, loss of license cover you have, so you understand how it operates. The other two elements of cover I wanted to touch on here were probably legal expenses and contract disputes. And similarly, they offer a cover which sits on top of and is very similar to loss of registration in some part, because the legal expenses coverage, which again is not typically bought by all clients but by some, can provide some cover in the event of an appeal against any actions by the CQC. Of which loss of registration can also provide some cover there. So we would advise talking to your broker about the benefits of any legal expenses coverage, and if these differ to some of the coverages that you have under your existing policies. And the last point here I just want to mention on crisis management is a bit of a unique and new cover to the market. Again, not bought by lots of clients because it's fairly new coverage, but the idea here is that this is what we call a crisis management and reputational risk cover. And if there is an incident which ultimately causes something to occur by which there is a fine, by which you have a loss of license incident, and ultimately a loss of revenue and loss of profit, some of these products can provide cover. And effectively what they will do is they will trigger based on a reputational damage event, which could be a CQC investigation, a prosecution and a fine. And if there is a certain level of drop in revenue, the insurer can provide a backstop, which will cover a loss of profit. And the importance here is that you have to be a profit-making business. If you're losing revenue but you're a loss-making business, then there's not going to be any cover. But for the most part, that shouldn't be an issue for most clients. And they can provide elements of loss of revenue cover with a much broader trigger than you may have under, for example, a property damage and a business interruption policy. And there would also be some pre-loss crisis management costs prior to any result, which could work in your favour up to about £250,000. So again, it's a different cover, it's quite new, offered by some insurers like Beazley, and we recommend that you speak to your broking teams around it if we think it has any value, especially with changes in legislation coming up. So next slide, please. And the last point, which I just wanted to make really around what does this mean for insurer appetite, how insurers will review your risks and what we should be doing when we go to market with renewal submissions. It's very, very early to tell, but we anticipate that insurers will probably rely a little more on CQC scores as an assessment of quality of risk, especially with the changing dynamics that this will become less of a point in time score and more dynamic, as Duncan was saying, with the move to technology and on the portal. So what's really important here is that differentiating and showcasing underlying risk controls, as we've got in the last point, will really help support existing and new insurer appetite. And it will really sort of, I think, put a focus from renewal to renewal on risks that insurers see as managed very, very well versus those which need a little bit of work and some appetite. That being said, you know, more generally in the healthcare market at the moment, insurer appetite for new business, certainly from a liability perspective, has historically been quite limited. A lot of that driven by caution over COVID losses, but that is changing. So we are seeing some sort of green shoots of recovery, some increased insurer appetite, especially for those risks which are really, really well run. So with that, I think I'd probably like just to hand back to Duncan for a few key takeaways from some of the messaging which he's mentioned today before we wrap up. If we could move to that slide, please.
So what can you do to protect yourselves? Well, in terms of investigations, I certainly think getting advice early will help. It's good to get some thoughts of people who have been through this before, and any legal advice you get will be privileged, and therefore you won't have to disclose it. Everything you create outside of that will potentially be evidence. So what I say to people is always create it with that in mind. Think about when you're drafting an investigation report or conclusions about something, think how you would put it to the CQC inspector. How would you put it to a judge in court or even a coroner? It is worth thinking about the audience, because people were reading these things and you can influence them by the way in which you present it. So the sort of classic example was always an SI report that I read where there's no evidence whatsoever that neuro observations were taken. Well, there was no neuro-obs chart, but there was a witness statements from 5 people who all said they took them. So, you can be a bit more circumspect in the way you describe things that can perhaps dampen down the level of concern. And it's important that when you have identified issues and you can make improvements, do that, because that will play in very, very well during the investigation, and certainly when it comes to time for a decision to be made on whether a prosecution should be brought, whether it's in the public interest to do so. If you've voluntarily made improvements and resolved any issues that arise. Sometimes clients are a bit worried about making changes lest that be an admission that there was a problem in the first place. I don't think so. I think you will always be looked at in a more positive light by having made improvements, and improvements can always be made. In terms of inspections, I say to clients, be present and inquisitive. So by that I mean sort of making sure that you're asking questions of the inspector, what they want to see, have they got everything they need, and providing evidence, not assertion, to them. So if they're asking about something, show them what it says in the policy, show them an example of where that's happened, rather than just making the sort of bare assertions that things happen in a particular way. Especially with the new single assessment framework, they are going to be basing more decisions on the evidence in front of them, and that means the documents. That means audit results. That means examples of from care records, whatever it happens to be. I always say at the end of inspections, the inspectors are quite often quite complimentary, and then clients say, the report was nothing like that. They were really positive when they left, and now look at this report. So I do think it's always worth playing back to the inspection team what they told you as they left. So making some good notes and following up in an email. Thanks very much. Good to see you. Really pleased that you told us X, Y, and Z. So I do think it's worth doing that. And then if there are any queries, follow those up in writing with the evidence that supports what it is you're saying. So that's the end of the presentation. We have got a few minutes. If there are any questions you want to put in, they have to be done in writing. But if you address them to a particular presenter, we can get back to you now or possibly afterwards.
Henry, any questions, or shall we close off?
No questions from the group, but the recording will be shared round afterwards for all attendees, so they can watch that in their own leisure.
Super. Okay, well, in which case, Duncan, Wendy, thank you very much for today, and for Henry for running this. Any questions, as Henry said, please reach out directly, and we'll share the recording and slides after the meeting.
Thank you very much, everybody.
Thank you all.
Thanks
Bye.
all.